The defence of reasonableness was created by the Copyright Amendment Act, Moral Rights, in 2000. It states there is a defence to an infringement of moral rights where infringement was reasonable in the circumstances. Moral rights protect the creators of material, such as writers, directors, and performers, who may not necessarily be the copyright owners. They add an extra layer of protection to help ensure that work is dealt with fairly. The three moral rights set out by the Act are illustrated in the following examples. Firstly, there's the right of attribution, that the creator must be identified. Second, there is the right against false attribution, which prevents your name being used on something you didn't create. And thirdly, there's the right of integrity, which prevents work being subject to derogatory treatment, such as prejudice to the creator's honour or reputation. There's no defence of reasonableness to infringement by false attribution, so a failure to properly attribute, or a derogatory treatment of work, will not infringe if the action was reasonable in the circumstances. The Act sets out a number of factors to be taken into account when applying this reasonableness test. These are, firstly, the nature of the work. Second, the purpose, manner, and context for which it is used. Third, the relevant industry practice. Whether the work was created in the course of employment or under a contract of service. And lastly, if there are two or more creators, their views about the infringement. So, say for example, you work at a local cafe and your boss asks you to write and design a new menu. Your employer, who is the copyright owner, uses the menu but doesn't include your name on it as the creator. Here, they are technically infringing upon your moral right to be attributed. However, as the purpose of the menu was to communicate between the cafe and its customers, and as the menu was created during the course of your employment, and as it's industry practice not to include the creator's name on a restaurant menu, your infringement would probably be considered reasonable. This test of reasonableness has generally been praised for its wide scope. However, in a submission to the Australian Law Reform Commission, Dr. Matthew Rimmer did make 3 recommendations for its scope to be widened even further, which would align the defence more with how we use material in the digital age. Firstly, he recommended the test take into account the age of the copyright work and whether the author can be located. Second, he said it should recognise parody, satire, and transformative uses like remixes, which are increasingly common online. And thirdly, he said it should take into account human rights considerations, such as freedom of speech and freedom of artistic expression. He also argued the success of the defence so far strengthens the case for a defence of fair use in respect of economic rights, as is already the case in the United States. Unlike the limits in our defences to copyright infringement, which are defined by strict categories, the defence of reasonableness allows courts more flexibility to consider the law on a case-by-case basis. At this stage, there hasn't been much case law in Australia regarding the defence of reasonableness. However, as time goes by, hopefully we'll see to what extent courts are willing to define reasonableness to protect these moral rights.